We discussed the sales and lease contracts, terms, and what makes it a contract. We discussed who bears the risk of loss and when a party is said to take title. Now, performance by the parties. We're going to talk about, along with breach, we'll go more into breach, what constitutes a breach. Performance is, when you get right down to contracts, performance is what motivates the parties. It's the reason why they expend energies in getting to a contract. That by entering into such an arrangement, each has managed to extract from the other some binding legal commitment. The seller is legally bound to hand over goods and to stand behind whatever he or she has sold. The buyer is required to take the goods and pay for them. Should either fail to do what they have to do, the other will have the support of the courts in getting a remedy. So the duty to perform is at the very heart of contract law. To understand performance, it is necessary to know the duties and obligations each party has assumed under the terms of the contract. Under the UCC, the basic obligations of good faith and commercial reasonableness underlie every contract. We've already talked about good faith. We've talked about commercial reasonableness. This is a continuing pattern that really underlines the obligations of both parties. Albert's required to contract to deliver 2,000 washing machines to various locations in Ohio. Deliveries are to be made on or before October 1st, and the locations are to be specified later by Farrell. Albert has repeatedly requested the delivery locations, but Farrell has not responded. On October 1st, the machines are ready to be shipped, but Farrell still refuses to give Albert the delivery locations. Albert doesn't ship on October 1st. Is Albert liable? No, right? This contract, somebody's supposed to provide, the buyer or Farrell is supposed to provide the locations. If our buyer is not cooperating, then buyer can't do their job, the seller can't do his job, Albert in this case. So cooperation, the parties have to cooperate with each other. They have to act in good faith and with commercial reasonableness. I don't think Farrell's acting in good faith here. We have other basic obligations that are outlined by the UCC for each party, both the seller and the buyer. Let's talk about the seller. What is the general duty of the seller? To make timely delivery of conforming goods to the buyer or the lessee. Conforming goods, what are conforming goods? Goods that conform to contract specifications. 1,000 red iPhone cases, not 1,000 blue iPhone cases. What is delivery? Tender of delivery. Sellers or the lessor their act of placing those conforming goods at the disposal of the buyer or lessee and providing whatever notifications reasonably necessary to enable the buyer or lessee to take delivery. What's timely delivery? Well, what the parties have agreed to. Otherwise, what's reasonable time and manner on good faith commercial standards? There's that language again. Dairy Products Inc., the seller calls Grocers Supply, the buyer, at 2 a.m. and says, the goods are ready, I'll give you 20 minutes to get here. Is this reasonable time and reasonable manner? No, unless they have agreed to that. But goods are to be tendered at a reasonable hour and time and kept available for a reasonable period of time to enable the buyer to take possession. How to deliver? All goods called for by a contract must be tendered in a single delivery unless the parties agree otherwise or the circumstances are such that either party can rightfully request delivery in lots. So for example, Trend Fashions Company, the buyer, contracts with off-the-rack clothing, the seller, to purchase 1,000 t-shirts with an American flag on them. The question is, can off-the-rack clothing ship the shirts 2 at a time as they are made? No. That's probably not reasonable. But can the parties agree that they can be shipped in lots of 4 of 250 shirts each? Yes, that's a reasonable, even a reasonable request at a party. Can the price be apportioned accordingly? Yes. because this may be commercially reasonable. Where to deliver, or the place of delivery. If the contract doesn't specify the place of delivery, UCC is provided for the place of delivery. That's really going to depend on whether we're dealing with the non-carrier cases versus the carrier cases. So we'll talk about the seller's obligations with regards to that. In non-carrier cases where the buyer's picking up the goods or the goods are stored at another location like a warehouse, if buyer's picking them up, the designated place is the seller's place of business. If the seller doesn't have a place of business, then that is going to be the residence of the seller. If we have identifiable goods that are in a warehouse and the parties know the goods are at this location at the time the contract is made, delivery is just going to be where the location of the goods are. In our carrier cases, where the parties intend to use a carrier to move the goods, like a trucking company, railroad, the seller's obligation depends on that type of contract. Are we dealing with a shipping or a destination contract? If we're talking about a shipment contract, remember our shipment contract, under these contracts it requires the seller to put the goods in the hands of the carrier. They're shipping by a carrier. It does not require the seller to deliver goods to a specific destination, just to put the goods in the hands of the carrier. But they just can't leave the goods on a docking platform with an address on it. The seller does have some duties related to this. They have to put the goods in the hands of the carrier. They have to make a contract for the goods transportation that is reasonable according to the nature of the goods and their value. What does that mean? If the goods require refrigeration, that transportation better have it. Obtain and properly deliver or tender to the buyer any documentation necessary to enable the buyer to obtain the goods from the carrier. So make sure the documentation's in order and notify the buyer promptly that the shipment's been made so the buyer can make arrangements for accepting those goods. If the seller does not do any of these things and there's a loss or delay, the buyer can reject the shipment. Under a destination contract, remember this is where the seller agrees to see that conforming goods will be duly tendered to the buyer at a particular location. The obligations here, the goods must be tendered at a reasonable hour and held at the buyer's disposal at a reasonable length of time. This allows the buyer to inspect. The seller must also provide the buyer with appropriate notice and any documentation from the carrier. The perfect tender rule. Under this rule, the goods and the tender of delivery must conform to the contract. If either of these fail, the buyer or the lessee can accept goods, reject all the goods, or accept parts or reject parts. If goods can be divided into units, that is, they can accept and reject parts. There is an exception to this rule. The perfect tender rule does not apply if the parties agree that defective goods will not be rejected if the seller is able to repair or replace them within a reasonable time. I note this pertains to conforming of goods, not the delivery component. This is the conforming of goods. This is that cure that I alluded to in another video. So a cure is the seller's right to repair, adjust, or replace defective or non-conforming goods. How seller's cure works is when any tender or delivery is rejected because of non-conforming goods and the time for performance has not expired, the seller can notify the buyer promptly with intent to cure and can do so within the contract time of performance. This only applies if performance has not expired. For example, buyer contracts with seller for red, white, and blue striped t-shirts for a 4th of July parade with a due date of July 1st. On June 30th, red, yellow, and blue striped shirts are delivered. And the question is, can the seller cure? Well, if it can do so within 1 day. If performance time has expired and the seller has reasonable grounds to believe that the non-conforming tender would be acceptable to the buyer, the seller can still exercise a right to cure. Why the right to a cure in the example that we're going to do next? Think about that question. In the past, Ready Electronics frequently allowed the Topps company to substitute certain electronic supplies when the goods Ready ordered were not available. Under a new contract for the same type of goods, Ready rejects the substitute supplies on the last day Topps can perform. Does Topps have a right to cure in this case? Yes, they do. Topps had reasonable grounds to believe a substitute would be accepted. Why? Because they did it in the past. So Topps can cure within a reasonable time, even though conforming delivery will occur after the actual time limit for performance is allowed under the contract. This, and I'll note, this right to cure restricts the right of buyers to reject. If the buyer is rejecting goods for non-conforming, it must do a few things. 1, disclose the nature of the defect to the seller. 2, act in good faith. And 3, state specific reasons for refusing to accept the goods. A buyer's failure to do so prevents him from raising a defense that the goods were defective. So all 3 of those things must be met. Some other rules: substitution of carriers. If the agreed upon manner of delivery becomes impracticable or unavailable through no fault of the parties, a commercially reasonable substitute is sufficient. Installment contracts. Installment contracts aren't separate little contracts. It's one big single contract, but requires or authorizes delivery in 2 or more separate lots and to be paid for in each separate lot. For example, seller refrigerated appliances is to deliver 15 freezers in 3 lots of 5, each to buyer home appliances. In the first lot, 4 of those freezers have defective cooling units which cannot be repaired. The question is, can home appliances reject that entire installment contract or just this first one? They can actually reject the entire contract. A buyer can reject the installment contract only if the conformity substantially impairs the value of the installment and cannot be cured. Well, in that example, the first lot came and 4 of the freezers had defective cooling units and they couldn't be repaired. So it kind of really jeopardizes the whole installment contract, right? It would substantially impair. So here are the 4 freezers. They can't be fixed. Substantially impairs the value of the installment contract and it can't be cured. Commercial impracticability. Whenever occurrences that are unforeseen by either party when the contract was made, that's rendering performance commercially impracticable, the perfect tender rule is no longer going to hold. The unforeseen contingency must be one that would have been impossible to imagine in any sort of given business situation. So that's the key here: impossible to imagine in any given business situation. These kinds of cases where somebody's going to argue commercial impracticability, these are very fact-specific types of cases. Usually involve acts of God. Maybe the COVID pandemic could be a good argument in this case. Workers who go on strike in a particular industry unbeknownst to the parties, that would be an example. So, like I said, these are very case specific. Destruction of identified goods. When goods are destroyed through no fault of the parties and before the risk passes to the buyer, the parties are excused from performance. So, unfortunately, the risk would remain on the seller because there's destruction of the identified goods, that you don't have a contract anymore. But what if the goods are partially damaged or destroyed? The buyer can inspect and can either accept with a reduced price or void the contract. Obligations of the buyer to furnish facilities reasonably suited for receipt of the goods, inspect the goods, and make payment at the time and place the buyer receives the goods. Those are the 3 obligations of the buyer. Payment is made by the means that the parties have agreed to. If it's cash, the seller has to give the buyer reasonable time to get it. If on credit, payable within 90 days, and the credit period clock starts from the date that the goods are shipped. Inspection, well, unless otherwise agreed to, and also buyer can waive inspection should they choose to, but otherwise, if not agreed, when arranged, the buyer has an absolute right to inspect the goods before making payment. This is exceptionally true when we're talking about cash on delivery, that the buyer has the absolute right to inspect the goods before paying for them. Why? Well, it allows the buyer to verify that the goods are conforming, right, to the contract. If the goods don't conform, there's no duty to pay. Where does inspection happen? If it's not agreed, or it's not a cash on delivery where it has to happen instantly, any reasonable time and place and in any reasonable manner. Of course, we're back to this reasonable time, place, manner idea. So what is reasonable is going to depend on the custom of trade practice or even the party's past practices. So some examples could be seller sends one widget after built one and sends it to the buyer, says, hey, how does this look? Right? Another example is 100 widgets delivered to the buyer and pay within 60 days of receipt. So the buyer can check them out during that 60-day time period. If the seller is, building something like a specialty machine for the buyer, there could be a number of inspections where the buyer goes and looks at it, part by part when it's being constructed. Revocation of acceptance. This occurs when the buyer has already accepted the goods, but then withdraws that acceptance and seeks to return the goods. This can only happen if a nonconformity substantially impairs the value of the good and if one of the following factors exists. The first being acceptance was given on a reasonable assumption that the nonconformity would be cured and it wasn't within a reasonable time. Or two, discovery of the nonconformity was difficult to discover before acceptance, or the seller's assurance that the goods were conforming kept the buyer from inspecting the goods. So we need a nonconformity that substantially impairs the value of the good and one of those other components in order for a buyer to then revoke an acceptance that the buyer had already given.